Hello, hello, it's Patty Jo. It's been such a long time, like a week or so. I totally messed up the sound on this, and it took me days and getting a sound person in here to show me what I did wrong. I know it's still not perfect, but I'm working with what, Anyway, we are going to continue. This is day, what is this? 12. We're at day 12. And I think I've got this queued up right. I've been working on that.
12:10. I do have Mr. Brooks in the other courtroom so that I could make an adequate record without interruption. We are on day 15 of trial, and today has been a rough morning to say the least. We are in the stage of this trial where Mr. Brooks has the right to present relevant and probative evidence and to call witnesses. And I have done my very best to honor his rights in that regard. Part of this morning dealt with his, from my perspective, disagreement with how I, yesterday and in the days preceding that, set up what I thought was a very reasonable way for witnesses to be called into this courtroom on his behalf. Going back to when the state offered to serve subpoenas on his behalf and talk with or coordinate with these witnesses to come into court. And yesterday, I wanted to narrow things down a bit, as is my not only right, but frankly my obligation under 906.11 to make sure that there is an effective presentation of evidence.
No, we gotta stop that. Seriously? Really? Oh no, girl. Such a disappointment. You make this so easy even for me to find you looking like a dupe. Look at this ball. Oh my God. All right, so let's back up a minute because I know it's been a minute since I've been here. Basically, the last time we were here, Daryl was starting his whole witnesses, his Perry Mason moments that he thought he was really putting out there. And he although expects, narcissistically gaslights everybody, manipulates into having everything done for him, and the expectation that that's what it's supposed to be, like we're supposed to all just flourish this unto him. And like my son who was telling me how horrible I was, kiss his holy toes. But he wants to make this secret. He thinks that it's supposed to go like a television show. Like he's going to pop up with some evidence that's going to exonerate him from the horrific things he did that on 1,000 videos. Like, I can't even say it without bringing that back up. Okay, I'm going to totally give up my son in this one. He was a very good kid. He was also a very stupid kid. And he was going to skip class one time. So instead of like the rest of us like sneaking off into the bathroom between classes and kind of hiding in the stalls until the bell rings and then everything's quiet and then go find some place to go, he runs out the front door where the teachers are coming in from their lunch hour yelling, "Stop that kid." That's like Daryl. He just thinks it's supposed to be this Perry Mason thing. I just don't know. I don't know.
Of
Look at him.
and exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. And let me just back up a moment, because I think it's worth putting into the record once again the full language of 906.11, which is entitled Mode and Order of Interrogation and Presentation. Number 1, control by judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. Make the interrogation and presentation effective for the ascertainment of truth. Avoid needless consumption of time. Protect witnesses from harassment or undue embarrassment. The next section, a witness may be cross-examined on any matter relevant to any issue in the case, including credibility. In the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct examination. The next section, leading questions. Leading questions should not be used on the direct examination of a witness except as may be necessary to develop the witness's testimony. Ordinarily, leading questions should be permitted on cross-examination. And then the next part talks about civil cases would not be applicable in a criminal case. So that is a statute that guides what I do, not just in this case, but in every case that comes before me for trial, or even a motion hearing. And in my almost 11 years on the bench, I've presided over dozens and dozens of cases that have gone to trial. To say that this has been the most challenging of my career would be an understatement. I have done my best, I believe, to be fair, to be unbiased, to protect the rights of not only Mr. Brooks as it relates to this trial, but those of witnesses, those of the victims, and of course, last but not least, the jurors. Prior to the court taking an early lunch this morning, a couple of things happened that I think are worth making a further record about. Going to the beginning of this morning, where it is true, I did not do my usual practice of asking if there were any preliminary issues that the parties wanted to address. In my mind, I wanted to get to the witnesses. We are at that stage. I knew there were a number of witnesses to be called, and I wanted to ensure that it was done effectively for all of the reasons that are stated in 906.11. And I thought it was reasonable at the time to simply take up issues dealing with legal matters at a break. That's why I brought the jury in. During the jury coming in, Mr. Brooks continued to talk, make statements. The record speaks for itself. I'm not going to, frankly, I couldn't tell you everything that was said at that time. At this point, I think it's important to note, though, it's the tone, the demeanor, the decorum, or frankly, the lack thereof for many days on end throughout this trial. It has become apparent that when the jury comes into this courtroom and leaves this courtroom, that Mr. Brooks makes disparaging remarks about the integrity of this court, of these proceedings, and of other parties in the courtroom. He repeatedly references things such as subject matter jurisdiction, which there is a written decision that I have filed in this case. It is very clear this court has subject matter jurisdiction over this case. This is not a civil case. This is not a case in federal court, for example, where subject matter jurisdiction sometimes becomes an issue for things like whether there's a federal question that's involved. Every now and again in a criminal case, subject matter jurisdiction is a type of issue that comes up, but not under the circumstances here. I'm not going to rehash everything that's in my decision. I stand by that decision. The record has been made abundantly clear that Mr. Brooks does not believe this court has jurisdiction. His objections have been noted, well documented by the record that's being taken down. I know from my experience, not only as a judge, but as a litigator, that once that objection is made, it's preserved. I even stated at one point, I think there's a standing objection. I will note that for the record. Mr. Brooks continues, in my opinion, to bring this issue up in front of the jury to distract, to delay, and to call into question the integrity of these proceedings. Frankly, maybe to create an issue on appeal if he is convicted. I brought him, I should state it this way, he is not in this courtroom presently because on day 15 of this trial, and specifically this morning, right, we have a history of disruptions, delay, interruptions, disrespectful behavior, the common courtesy, I think that just as a human being we all would expect, have not been followed. It's evidently made, let me restate that, it is evident to this court that when there is a ruling that Mr. Brooks disagrees with, whether it be an evidentiary ruling, whether it be on subject matter jurisdiction, whatever it may be, that he has a pattern now of directly confronting the court, asking for, is that verified law? Can you prove that? Is that an actual law? He starts debating the topic once again, or he will even try to further turn us away from that by bringing up another topic. For example, just today, when the issue came up about this letter that he claims was sent to him by Erica Patterson, and I asked repeatedly for an offer of proof rather than answer the question directly, Mr. Brooks instead started talking about an exhibit the state offered into evidence yesterday. And from my perspective, he doesn't address the merits of the issues that are before this court and then tries to divert things down a different path, whether that's to delay, to disrupt, or just simply be discourteous. I think all of those words would be an accurate description of what is happening. That was one piece of, or one objection or series of objections that I actually went off the record. Not off the record. I actually dismissed the jury in order to try to get an offer of proof from Mr. Brooks. And as that exchange went on, it got, from my perspective, he got louder, he got more disrespectful. I think it's fair to say his behavior was volatile, and it's because of that that I called an early lunch. And it's because of all of those things. Even when I attempt to give the warning that he will be removed upon further behavior, he immediately interrupts and says, "Are you holding me in contempt?" A very clear indication to this court that he is attempting and trying and actually disrupting the proceedings so that I can't make an accurate record. Like I said, it's challenging. That is why he is in the other courtroom muted, so that I can make the record. And I will confirm with my clerk and the bailiffs. I should have done this at the beginning, but I believe, thank you, my clerk did confirm that they can see, they can hear, we can see as well. It is this court's opinion that Mr. Brooks is blatantly pushing the limits of what I have tried to establish in terms of when to call witnesses, how to call witnesses. He pushes the limits on asking questions that are not probative, that are not relevant, or that directly contravene a prior ruling by this court related to other acts evidence. That ruling that I made was to the benefit of Daryl Brooks, not the state, Daryl Brooks, the defendant. There have been multiple witnesses who have themselves stopped, basically looked at me and can I answer that question, basically? Is there nonverbal communication to me? Or some have actually said, I don't think I can answer that. There have been other witnesses where I've stopped them from answering so as not to bring in the other act's evidence. The most recent of which occurred this morning with Erica Patterson, and the repeated questions to her related to either information she did or didn't give the detective when the detective spoke to her on 2 separate occasions. There's been other questions throughout the trial to, I believe, to Detective Guth directly and other witnesses who had information about why that may have been the case. But this witness, I think, has been very, very careful to not run afoul of the court's prior ruling. That leads to the evidence claimed by Mr. Brooks that he has related to a letter and photographs. As I indicated before the break, I've looked at both 906.16 and 906.08. Those are generally 2 of the statutes dealing with character evidence. That would be 906.08. 906.16 deals with bias. From my perspective, the questions that were actually asked and answered about do we have a child together? Well, he didn't ask it quite that way. I'm summarizing, but regarding their common child, regarding whether he sees the child on or off, where they met, things of that nature, are solely to attack her character, as a mother, which is wholly improper. The only character evidence that would remotely be allowed under, at least for a witness under these circumstances, would be character for truthfulness, which would not even be from this witness. It's typically another witness comes in and testifies to that, and only about opinion evidence, their opinion of the person's character for truthfulness. Under bias, 906.16, I didn't see where it also related to her credibility. It says, for the purpose of attacking the credibility of a witness, evidence of bias, prejudice, or interest of the witness for or against any party to the case is admissible. Again, simply attacking her on her motherhood. That's my perspective. I did not receive the answer to the repeated questions I asked regarding the offer of proof and this letter that he claims was sent by Erica Patterson, and then the photos. The issue as it relates to this witness is a single charge in the case. It is a battery charge with a date of violation that is alleged to be November 21 of 2021. To allow Mr. Brooks to ask the witness about contact after that point in time is not relevant. He has not given me any reason as to why it's relevant. The state also, I think, rightly points out that if those questions were to be answered by Erica Patterson and other questions along those lines that were questions that were objected to by the state and that I sustained, Mr. Brooks would open the door to what only could be described as very damaging evidence against him, related to the other act's evidence, related to whether he has a relationship with the children or not, and frankly, a topic I am not going to open the door to. I'm not going to allow it. It's a side issue. It is not relevant. It is not probative. But certainly one could argue, based upon the questions, topics that the door could be opened to. It is my duty as the judge assigned to this case to ensure that the trial is fair, that relevant and probative evidence comes in, and that it is done so in a way that's effective and efficient for the presentation of evidence, including the testimony of witnesses. And so I'm not going to allow questions related to the children in common or child in common, at least any further, between Mr. Brooks and Ms. Patterson, when they met, how they met, the nature of their relationship now, whether there's been any contact between them since he was arrested and going forward. Because nothing that I've been presented with would suggest it relates not only to relevant and probative information, but even to her credibility as a witness. I will give Mr. Brooks a final opportunity to make an offer of proof as to why he believes my decision is wrong.
Oh my God.
That needs to include an offer of proof as to why he believes this letter is from Erica Patterson.
No letter.
And why it's relevant to the issues in this case. Because he came in to the courtroom this afternoon and is not in here but in an adjacent courtroom, I want to make some additional findings as well and kind of just tie up a few loose ends for the record. As the Supreme Court in Illinois versus Allen stated, it is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. Trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. This court has utilized an adjacent courtroom with superior audio and video capabilities that I believe are the functional equivalent of being present in this courtroom. Mr. Brooks's behavior today alone was disruptive. I would absolutely characterize it as stubbornly defiant. It was interruptive, and it certainly aggravates the proper administration of the criminal justice system, of this trial. There was nothing dignified about it. There was nothing orderly about it. I would remind him once again of SCR Chapter 62, which are the basic expectations of courtesy and decorum in the courts in the state of Wisconsin. I'd remind him of the golden rule. Do unto others as you would have them do unto you. Be respectful. Be kind. Give these proceedings the due respect that they deserve for himself. I do not believe he even shows respect for that. I'm not looking for any further input on the issue of removal or any further record. I wanted to make that record without interruption, which is why Mr. Brooks was in the other courtroom. When we come back to this courtroom, I will ask Mr. Brooks for an offer of proof. He will be brought in, so we'll go off the record for that momentarily. An offer of proof, if he wishes to do that, related to the letter and further questioning. I also want an offer of proof as to what probative and relevant information Ms. Patterson will be testifying to based on his direct examination. This is a witness who was called by the state initially. This is a witness where Mr. Brooks had a full and fair opportunity to cross-examine her on a prior date. He was allowed to call her himself. The vast majority of the testimony today has been a rehashing and a representation of her testimony from the other day. I'd have to look at my notes for the date. October what? 7th. October 7th, I believe she was the third witness. We did not glean anything new, probative, or relevant through the course of the questioning today. Because he's had a full and fair opportunity to already cross-examine her, because he's had a significant amount of time this morning to question her, I will require that offer of proof, and then I will make a decision whether any more questions will be asked of the witness. At this point in time, does the state anticipate any cross of Ms. Patterson? But I'm going to ask that when we come back, when everyone is here. With that, I am going to take a very short recess to have Mr. Brooks brought back into this courtroom so that we can continue with testimony and evidence. Thank you.
Okay, so I'm going to stop it right there for a second. I think she did a pretty darn good job wrapping that up. It was a dumpster fire. She cleared the record pretty well, in my opinion. I'm not a lawyer, but from what I heard, she broke it down into the sections. She addressed each one. She backed it up legally. She was succinct. Very good job, in my opinion. And I think these are the highlights for her, where she is saying, I know this was a dumpster fire. Here's what we're going to do to clear up the record, and here's what we're going to do moving forward. He was given the chance to recall her out of, abundance of making sure he gets a fair shot at asking all the questions. He failed to ask any question that was new information from the last time that she was here. And, unlike bringing in that detective again, as a good example. And so now we're just going to close this down. Let's see how that goes. Let's just see how that goes, because I think we know how it goes.
Mr. Brooks, I'm advising you, you are invited back to this courtroom. It is my sincere hope that you want to come back here. I see you're reading something. But we are at the point in this trial where you have a witness still on the stand, obviously figuratively at the moment, not literally. And I'm going to ask you if you are ready to answer my questions from previously, and also to let me know whether you are asking to stay in that courtroom.
Isn't that how we treat toddlers? Are you ready?
You've been advised. He can hear and see.
Oh my goodness.
Mr. Brooks, we are on the record. I'll go through the topics one by one. You are in the other courtroom. You are invited back here. Would you like to come back here? Yes or no?
Are we supposed to be back on the record?
Yeah, she's asking a question.
The audio is on. Would you like to come back to this courtroom, sir?
Unmuted.
You're unmuted.
So I'm finally unmuted.
You've been unmuted for a while. since I came back on. My understanding, sir, is you'd like to be in that other courtroom. Is that true?
Oh my God, here we go. Shenanigans!
Record to reflect he's putting on the headphones.
What's going on?
Mr. Brooks, I'm inviting you back to the courtroom. My understanding from a relay of information from the bailiffs is that you don't want to come back here.
I ain't say nothing.
I didn't
All
say
right, are you ready to come back then?
Not if I'm just gonna get held in contempt again.
I didn't hold you in contempt.
Then why am I even over here?
So that I could make a ruling and make a record without an interruption pursuant to my authority in Illinois versus Allen.
So did you make your record?
I did.
Am I ever gonna get a chance to make the record without being interrupted?
Nope.
Mr. Brooks, I'm asking you, the first question is, do you want to come back into this courtroom?
Not if you're gonna hold me in contempt.
Sir, I
I
need
don't
to
wanna
continue with the trial.
I don't
So
wanna
if
keep
you
being
don't
held in
answer yes
contempt.
or no, then I will presume you want to be in that courtroom, and you'll, by your conduct, waive your right to be in this courtroom.
By what conduct? I didn't consent to
By
being held in
failing
contempt.
to answer my question, sir. So I'll ask you again.
Are you gonna hold me in contempt? I don't want to be held in contempt.
I will ask you again, sir. Would you like to come back to this courtroom?
I'm supposed to be in there anyway.
So twice now I've asked him. He has not answered a yes or no. Mr. Brooks, I'll ask you a third time. Would you like to come back into this courtroom?
Yes, if you're not gonna hold me in contempt.
Given his yes, I will close the courtroom. He'll be brought over, and then we'll continue when he comes into this courtroom. Thank you.
And for the record, I do not consent to being called that name.
Yeah, I'm always muted. I don't know why she think I
Caramel
can
on my
hear everything
teeth.
she's saying perfectly clear without the headphones.
I can hear it so much
That's
better
the trick
now.
to hold
I don't know
everything
if the
up too,
sound
right?
is working right, but I can hear everything he's saying in that other courtroom right here. So I hope it's working right. You guys are going to have to tell me. I'm sure you will.
Yeah, might as well stay over here.
I heard the shackles too. All right.
Record, it's 12:48.
I'm getting better. I'm getting better
All right,
at
let's
it.
take
I'm
up
so
the
proud of
issue
myself.
of the letter and the photographs and your offer of proof, sir, if you
my
have one.
Lord.
I don't need no offer of proof.
I'll ask you a second time. Do you have an offer of proof
We
to
can go
provide,
past all
sir?
that. We can go past all that. I don't need to ask them questions. It's too much of an issue. It's too much of a problem.
Mr. Brooks, I'm going to ask you for a third time. Do you have an offer of proof?
at it!
I just said
to
no.
the route-
I just said no. I just said that.
All right, thank you. Then, based upon there being no offer of proof, then
Did you see that numbskull behind him? I don't think he deserves any more attention.
my decision stands.
Team
As to
Skeptic.
the continuation.
I think it was Team Skeptic who is great, by the way. I've watched him do some of this stuff too. It's way better than I could do. But was it him who he said, I think it was him, but anyway, whichever, I'll try to dig up who it was. But then the guy answered back and said that he was the one that was interviewing him at that bus stop. And that's not true. He just, he's a mess, that guy. It's Erica's fault.
Of the examination of Ms. Patterson, I would like an offer of proof as to what you believe her probative and relevant testimony will be from this point forward.
I mean, I don't know how she's going to answer the rest of the questions. There's not that many questions left. I was almost done.
What topics generally were you going to question her about?
He doesn't have
I guess
anything.
I'll have to look in here because so much that happened since over the past hour and a half or so. I can tell you one thing. I don't intend to have too many more questions. I tell you that. I was almost finished.
I need an offer of proof as to what you believe her testimony would be, meaning what topics. And are they topics that have not already been covered either through her direct examination from the state, your cross-examination, or already covered by your direct?
I don't remember her. What do you mean by related to her direct? Is that from the last time she testified?
From the first date that she testified and from today. What new topics will you be?
I don't remember everything she testified to the first time. It was 2 weeks ago.
Well, Mr. Brooks, this is your opportunity to prevent relevant and probative evidence, but under 906.11, she's already been questioned now twice by you. So what new topics do you intend to question her about when she comes back on the witness stand?
What do you mean by new topics?
Oh!
Topics that you haven't already covered.
What, pursuant to the police report or something? Is that what you're asking? I don't understand.
I'm asking you. I'll ask you once again, sir, give me an offer of proof as to what you believe your questioning will be as to Ms. Patterson going forward.
And you say it related to topics, right?
You can just give me the topics. I think that's fair.
I wanted to ask questions about the police reports. That was the last few questions. That's why I'm saying it was only...
Is it a statement that she wrote?
I don't know if it's a statement that she wrote in here.
Do
Possibly
you see a written statement with her signature
I will
on it?
have to go through all the paperwork.
Is there a written statement from Ms. Patterson?
No, Your Honor.
It's my understanding Detective Guth spoke to her on both occasions. Is that right?
Yes, with Detective Barrett with him on the first occasion. Detective Barrett wrote that first report. Both interviews were also recorded.
Previously provided with discovery?
Absolutely.
What about the police report, sir? Do you want to question her about so I know with specificity?
Oh, I'm looking at it now. How many officers did reports? Because it seemed like it's more than just 2. At least from this paperwork, is more than 2.
A real lawyer would have a plan of what evidence and who would know that, and then ask those questions. Daryl, dumb goblin, stupid old thug. You're so exhausting.
May I have Bill show me what
Mr. Brooks is referring to? I can maybe help him try and explain, but
Sure.
I don't know what he's talking about.
I can't find the first page to that, but whoever that officer is right there. That's a statute.
So I've got pages 2 and 3 out of 6 from Detective Barron's report under Waukesha Police Department incident number 21-047533. This is one of the two reports we've been talking about regarding the statements that Ms. Patterson gave to detectives on November 21st and then on November 22nd. This is the first statement.
Is that the officer you just said?
Yes.
What about that report do you want to question this witness about?
The report is not in order, so again, as I stated before, I would have to read it.
Mr. Brooks, I trust that you're prepared. These are your witnesses. So what about that report do you want to question Ms. Patterson on?
Your Honor, I just stated 3 times I would have to read a little bit of this to form the questions.
Under my authority, under 906.11, then, and given that this witness was initially called by the state, there was a full and fair opportunity for cross-examination by Mr. Brooks at that time, and they had ample time this morning to question her, I will declare that his questioning of her to be closed. I will bring the witness out on the witness stand and then we'll bring the jury out, and then I will simply ask the state if there are any questions, and then we'll move on from there.
Just so I understand what you mean by closed.
I'm not allowing you to ask her any additional questions, given your full and fair opportunity that you had previously when she was called by the state, and given the opportunity you had this morning and your failure to identify for this court any probative and relevant information that she would testify to about what's in that report.
How do I, first of all, the report isn't even in order.
That's
So I
not
would
her
have
fault.
to essentially read at least some of it to even ask a
Mr. Brooks,
question.
this is your witness. I expect that you will be prepared and you will not cause delay by any lack thereof. So I'm bringing the witness out, the jury will come out, and you will not have another opportunity to ask any additional questions unless the state asks questions on cross-examination.
So what is we bringing the witness out for? Then,
I have
if
to
What
do that
is
in front
we
of the
bringing
jury.
the witness?
Man, I object to that ruling too. Can you give me a lawful law why?
A law-
Your objection is noted for the record. If you start interrupting me when the jury comes out or make any commentary, you will be removed to the other courtroom, and that's,
So I'm being held in contempt again?
no, it's not contempt, sir. It's a finding under Illinois versus Allen. It's a warning that you will forfeit your right
So I
to
might
be
as well just
present.
I might as well have just
No
stayed over
such
there.
contempt finding.
I might as well have just stayed over there then if I was
Mr.
going to get held in
Brooks,
contempt.
that decision is for you and you alone to make, and it is based on your conduct. If you're going to
Just take me over
continue,
there. Just take me over there because I'm not finna get held in contempt for nothing.
I have not held you in contempt.
You did.
You're
You're attempting to hold me in contempt. That's what that is.
No, that's not contempt.
So is it civil or criminal? Why am I being
Mr.
held in
Brooks?
contempt?
I'm
That's
going to
the-
keep
that's
you
the
in
whole-
here because
that's the whole reason
you're going
I
to need
didn't
to
wanna
call
come-
the next witness, and I'm going to need
Your
to
Honor.
bring you over in any event.
That's the whole reason why I didn't want to come over here, because you was going to find a reason to hold me in contempt.
Well, I'm finding a reason, and it's not contempt, but I'd find a reason to remove you based upon your disruptive outbursts.
Well, then remove me if
and
that's
your-
what you want to do. Remove me then.
I don't want to do it, sir. I want
Obviously you
in
do.
this courtroom.
Obviously you do. You brought it up before we can even get to.
All right. Mr. Brooks has forfeited his right to be present in this courtroom for the remainder of this witness. Even
So
though
did
it will be
I
short,
actually forfeit that right?
you have forfeited your right to be present. That
And
is
how
the-
did I forfeit that right, Your Honor?
All right. We're going off the record so that he can be removed to the other courtroom, and he can call his next witness after we complete with Ms. Patterson and giving the state an opportunity from the neighboring courtroom. And once you can promise to this court that you will abide by the rules of decorum and civility, and if you're willing to conduct yourself consistently within that, then I will allow you to come back over.
So why am I being held in contempt now?
I'm not holding you in contempt.
Then what did I do?
All right, I'm going to step off. You've interrupted repeatedly. I'm going to step off.
This is excruciating. I want to get through where they get her off the stand at least. Oh my goodness. You know, I used to struggle because, not struggle, but when you're a fresh paramedic going out to the field and you really do think you want to help people, you think that's what you're there for, that's what you're doing, and you want to respect everybody, and what you find is people who live kind of a life, and then you wonder why you're in these situations, basically. You know, just like your mom and dad used to say, if you wonder why you're, I'm not victim blaming, like, you know, you wore your skirt too short, so you deserve to be assaulted or anything like that. Nothing like that. But just, you know, if we have a social construct, we work. Now, I know that the economy is just a hot mess, and I can barely afford what I thought I was going to be able to afford at this time of my life. But, you know, we work, we pay bills, we find a place to live. We do these things. If you need to get around, you get a vehicle, and you know there's just social construct. There's social construct, and working with as many and as deeply homeless. Now, some are homeless because of substance abuse, and some are homeless, you know, substances, drugs, or alcohol. Some are homeless because of mental illness, some combination of those, but some are just homeless because they don't want to follow the rules of society, those social constructs. They don't want to do it. And years and years and years will pass, and the way you reason and think disappears from these people. And a friend of mine from the dog park, she gave the exact word for it. It's primal. They no longer have higher levels of constructing a thought, and they're now primal. He is definitely that. It's even worse than being a child. That's being, you know, very rude to children. Children are developing that critical thinking skill. He never had it, or if he had any part of it, he totally lost it. But he's primal. Ugh. Let's see. Is you this? Is you that? Oh,
Feel uncomfortable?
Jury's coming in. Please rise for the jury.
I wonder what he said.
So that's not gonna be addressed.
Mr.
Okay?
Brooks, I'm muting you.
I wonder what he said.
Be seated. Madam Clerk, would you please have the jury brought out and make sure all the monitors are on? You are unmuted, sir. The jury is on its way in. Well, will be shortly.
Why didn't we address subject matter jurisdiction?
Oh.
I'm going to mute you if you do that, sir.
I'm not gonna do it when the jury. That's why I asked now before the jury came in.
I addressed that in my opening type remarks and record when we came back on the record today. I already addressed that.
So will it be proven for the record? Will I at least be told why I'm held in contempt when I didn't do nothing? Civil or criminal?
Do nothing. Civil or criminal.
That's a misstatement of what I did, sir.
So why am I
I
over
will
here?
advise when the jury's coming in, and if you can't be quiet, you're going to be muted, sir.
You gonna mute me anyway?
Not if you're quiet.
So I gotta be quiet like a little kid?
Yes.
It's not what I said, sir. You have to be respectful.
said.
You have to be respectful of the proceedings.
But nobody.
You gotta be quiet like a little kid. Yes. How many others are doing the same thing? Yes. Oh my gosh.
He has to be respectful to me though.
No.
That's a mischaracterization as well.
So can I say for the record that two of your bailiffs was just making gestures behind my head, and I seen them through the TV screen and made me feel uncomfortable?
Oh.
Jury's coming in. Please rise for the jury.
So that's not gonna be addressed.
Mr.
Okay.
Brooks, I'm muting you.
Middle District of Pennsylvania.
Oh, okay.
That's the federal district. That was appealed. It was on.
It was later affirmed. Okay. Can I have the preliminary instructions for a second? Oh, sure. I should just keep them. They're nearby. Thank you, everyone. Please be seated. Just for the record, Mr. Brooks is appearing from another courtroom. That should not affect your deliberation or verdicts in any way. At this time, does the state have any questions for this witness?
I don't have any questions for Ms. Patterson.
All right. Thank you, ma'am. You may step down. Thank you for being here. All right, the defense may call its next witness, please. Go ahead, sir. You can call your next witness.
I thought I was muted.
You're not muted.
So how long am I supposed to stay in here now?
I'm going to excuse the jury. We'll hopefully have you back shortly.
God!
All rise for the jury, please.
Oh my gosh! Oh, this is exhausting.
All right, the jury is no longer in the courtroom. Mr. Brooks, I had the jury leave the courtroom because it appeared to me you wanted to perhaps either ask to come back into the courtroom or make another record of something. Do you want to come back into this courtroom as you call your next witness?
I'm muted.
You're not muted. You're unmuted.
How we go through this every
So what's
time.
going on now? Why am I being held in contempt yet again?
The record will reflect that pursuant to Illinois versus Allen, Mr. Brooks was not held in contempt, although that is one of the possible ways for a trial judge to handle a
Buffoon.
defendant who is stubbornly defiant, disruptive, and contemptuous. That is not the only way in which a judge can
Buffoon.
address
That was the word you were looking for,
a
Judge.
defendant that is being discourteous, disrespectful, and disruptive. So pursuant to the authority in Illinois versus Allen, I found that you forfeited your right to be present based upon your conduct. I'd also direct the parties to some persuasive authority from other jurisdictions that are more recent, including People versus Cone from the state of Colorado, 160 P. 3rd 366. It's a Colorado Court of Appeals from 2007. And then from the state of Washington, from their Supreme Court, State versus Davis, 461 P 3rd 1204. That's from 2020. And then I'd remind the parties of the district court decision that was later affirmed from Pennsylvania, U.S. versus Jennings, 855 F. Sup. 1427 from 1994. The finding was, sir, that you forfeited your right to be present based upon your conduct.
Okay, and all those case laws you just cited are pursuant to that.
Sir, I will ask you, would you like to come back into this courtroom as you continue with the calling of witnesses and your next witness?
I thought you was using Illinois versus Allen.
She said
You
that
are welcome to
first.
come back into this courtroom, sir.
So why was I removed in the first place then?
I've made my findings. The record will stand. I will ask you one last time. Would you like to come back into this courtroom as you call your next witness?
You're not finna hold me in contempt
You're
no more.
You're finna.
Not finna do that.
Mr. Brooks is not answering my question directly, so based upon that, I'll advise him that if I will ask one more time and he fails to answer it with a yes or no, I will take that as a no, that he wants to stay in that courtroom.
You can't answer
Mr.
for
Brooks?
me. You can't do that.
You can't do that.
Mr. Brooks, I'm advising
Yes,
you that
you
I will. He's interrupting me once again. From
Okay,
the
you
other
talking.
courtroom.
You the one talking right now, so don't do that.
I'm going to mute him because he's not being.
Which means you were interrupting her. You idiot. Oh my god. What a total buffoon. What a total idiot. Oh. You know, sometimes when I argue, I wonder if I come off like this. Ugh.
Respectful, and he's just spouting off.
Yeah,
So
good point.
he did not answer my question directly. He has not reclaimed his right to come back into the courtroom because number one, he has not requested it. Number two, he hasn't answered my question about whether he wants to come back in. And number three, he hasn't stated or demonstrated a willingness to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I will give him one more opportunity. So that it's abundantly clear on this record that I am honoring his right to be present, and I will unmute him. Sir, would you like to come back into this courtroom as you call your next witness?
Don't try to seem like you're trying to honor my rights now because you haven't been
Okay,
doing
he
it before.
is, again, not answering the question directly.
Don't try to put on no, don't.
I'm going to mute him again. As I've noted before, this is a clear method now that Mr. Brooks is employing, that when I have done something that he disagrees with, that he just continues to argue with me and does not answer questions directly. So based upon his continued disruptive behavior, the fact that he will not answer my questions directly, I'll find that he is continuing to forfeit his right to be present in this courtroom. Clearly, the audio and visual technology are working. He's been responding, although not appropriately. He is in that other courtroom. We can see him. He does have the headphones on, and I confirmed that he can see and hear as well based upon the court personnel that are in the other courtroom. So I'll make another finding that his appearance from the other courtroom is the functional equivalent of him being present in this courtroom. Mr. Brooks, before I unmute you, I am going to advise you, I will ask you to call your next witness. And if I don't get a direct response out of you, I may ask it again. And if you fail to give me a direct response, then you will forfeit your right to call any other witnesses. So I'm going to unmute you. Actually, I need to bring the jury back out. But before I do that, I will unmute you first and ask you which witness you intend to call so we can at least have that person ready to go and outside the courtroom. Who will be your next witness?
I'm not calling no witness if I got to be in this other courtroom.
Would you like to come back into this courtroom, sir?
Why was I ever removed? You never answered.
I've made a record of that, sir.
I have to answer everything, though. Everything you ask me, you expect me to answer. But then when I ask you questions, you never have to answer anything. I just put on the record that 2 of your bailiffs just made gestures. When I'm looking at them off the reflection of the screen, they're making gestures behind my head that make me feel uncomfortable. I just brought that up on the record. You didn't even address that.
Mr. Brooks, I didn't address it because, frankly, you keep interrupting me, and then I have to deal with the interruptions and make a record regarding that.
No, that's true.
So
She didn't address it because you pepper sprayed the entire room with your BS.
So I just saw the captain walk over. I will let security personnel, Captain Dussault, look into that, and if appropriate, he can bring that conduct to my attention. I'd also remind the defendant that at any time you can also ask to be brought over through the bailiffs who are in that courtroom. So to be abundantly fair to you, I will ask one more time, would you like to come back over to this courtroom?
I should have never been removed.
That's not answering my question, sir.
You haven't answered my question.
So?
The court's not going to answer questions directed at the court by the defendant because they're not relevant or probative at this time, and they're a delay and disruptive tactic.
They're
Mr.
not
Brooks.
a delay and disruptive tactic. Is that a judicial determination?
Yes.
A judicial determination that you're making.
I'm going to mute you because we're going off on the judicial determinations. Every decision I make, sir, is by definition a judicial determination. It is on the record. If there is a conviction, you can raise whatever issues you want on appeal if you are convicted. But we don't need to have this back and forth every time to further make the record when the record speaks for itself. You were given plenty of opportunities throughout this trial to make offers of proof, to state your legal reasoning for either an objection or for a question that's being asked or for a whole host of other things. But right now you're not doing anything legally relevant. You're being disruptive. I would like you to be present. That is always what I want during this case. It certainly, I think, is important, but you can forfeit your right to be present by your conduct, which you have done repeatedly throughout this case. I will advise you that if you are in that courtroom, because I have put you there and you have not reclaimed the right to be present, by number one, asking and then expressing a willingness to conduct yourself consistently with decorum and respect inherent in the concepts of courts and judicial proceedings, you will remain over there. And it looks like he took his headphones off, so I would. Mr. Brooks, I'm advising you that if you fail to call a witness, you will forfeit your right to present any additional witnesses. And I'm doing this outside the presence of the jury right now for a reason. I need to know from you right now, you are unmuted, who is your next witness?
She trying to say something to me? Yeah. What you trying to say?
That was very disrespectful, sir. You chose to take off your headphones. You choose to read.
I'm muted. So why am I gonna have my headphones on and I'm muted?
Why don't you listen?
Well, I would think your headphones help you hear. The
They
muting
do.
is so that I don't have to hear the disruptions.
Okay, well then why should I need to hear what
So
you
let
saying?
me be clear, sir. And you
don't
are
gotta
not.
be clear or nothing. I don't gotta listen to you.
I will ask you one last time, sir. Who is your next witness?
First of all, is she talking to me again?
This.
We gotta keep doing this little childish stuff, dude.
Yes.
I gotta sit up here and I'm supposed to abide by every single rule, but don't nobody
Yes.
else gotta do that.
No, they do.
The record should
Judicial misconduct.
reflect that Mr. Brooks is spouting off, making unsubstantiated
I think the record can hear me.
allegations
I think they can hear me.
against this court,
Unless I'm
directly
muted.
attacking the integrity of this court and these proceedings, while yet
This court ain't got no
refusing
integrity.
to answer
This court don't have
simple
no
questions. Mr. Brooks, you
That's
are,
not my name. I told you I don't consent to being called that name.
sir, you are hereby advised this is the last time I will ask this question,
Don't talk
or
to me
you
like
will
that.
forfeit your right to present
Can't do that.
any
Show me what-
additional
show me
witnesses,
where that's law.
because
Show
you
me
are
where
not
that's law.
cooperating with this process.
Show me that it's law. That's all I'm asking. Show me that it's lawful law.
Mr. Brooks,
How can I forfeit not being able to have a defense? Are you kidding me?
This is how.
all I'm asking is that you conduct yourself with dignity, with decorum, and with respect. I will gladly bring you back into this courtroom so you can present your additional witnesses. But you need to ask me to come back into this courtroom.
With all due respect, I'm tired of having this back and forth with you every day. It's not my intention to come in here and have these interactions with you every day. It's not. Regardless to what you may think, regardless to how you may feel, that is not my intention. Okay? I simply do what I do because I do not have the understanding. So if I don't understand something, I'm going to ask a question. I apologize if it makes you feel that I'm intentionally trying to delay the proceeding. If I'm intentionally trying to be disruptive. Because that's not the case. And I feel very, 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 very disrespected every time the record is made, making it seem like that's what I'm attempting to do.
You are doing.
So of course it's gonna frustrate. Of course it's gonna make me a little bit upset.
It's gonna make me a little upset.
And I just want you to understand that. It seems to me the way I'm interpreting what you're doing, which is it is your courtroom. That's not a dispute. That's not up for debate. You control what's going on in there. That's not a dispute. But the way I'm interpreting what you're doing is that I'm being held in contempt. That's how I'm interpreting. Because one of the three things that's cited in the Illinois versus Allen, one of them is being gagged. I haven't been gagged. One of them is held in contempt.
What's the third, Mr. Brooks? What's the third?
You skipped it.
The third is removed from the courtroom while the trial continues, right? That's the third, right?
And that's what's been done.
Okay. So now, where does it say after that having me on a headset or being able to see and hear and all this and this, how is that not prejudicing my defense?
Sir, you can raise that issue on appeal. You can raise that issue on appeal if you are convicted.
This is why I say that though, because I can't even see. The only thing I can see right now when I'm looking at the TV is you in the prosecution table. I can't see anything else.
I understand that, sir. I'm fully aware of that.
So I'm not fully aware of what's going on in the courtroom. Don't I deserve that right to be able to see and hear everything that's going on?
If you can conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, the answer then is yes. So I'm not going to have a debate with you about the law. I will ask you again, would you like to come back into this courtroom?
Are you going to kick me out?
Sir, I'm asking the questions right now. Would you like to come back into this courtroom? Yes or no?
Are you going to kick me out?
Sir, it's a yes or no question. Would you like to come back into this?
My answer was based on the reason why I'm answering like that is because the moment I say something, it's going to get me put out. I don't want to keep hauling this stuff back and forth and back and forth and back and forth and back and forth. It makes essentially, it wastes time, really.
Wastes time, really.
I'm well aware of that, sir. That it delays the proceedings.
Yeah, but then it's laid at my feet as if that's why
look at you.
Think I want to be over here.
Sir,
Yes.
I don't know what you want or don't want at this time. I know that we need to complete this trial and that you have frustrated today more than ever before the ability of this court to do that.
Well, I apologize for you feeling that way, but I'm frustrated too. And nobody seems to take that into account. I'm just as frustrated as everybody. Probably more.
Then I suggest that you conform your conduct to the requirements of courtesy and decorum so that you don't run the risk of forfeiting your right to be present. But that falls on you and you alone, sir.
There is no conduct. I don't understand what you mean by that. I really don't.
Mr. Brooks, you may not understand it. I don't think that's accurate. I think you know exactly what you're doing.
If that's what you think, that's fine. I can't argue
And
with
you
you
have
about your
demonstrated
opinion.
throughout this case that you pay attention to witnesses' testimony, that you make cogent and coherent objections. At times that you have even had evidence suppressed in this case or stricken. That's the word I used during this case. You made an opening statement. You communicate with witnesses. So
Your
you
Honor,
clearly
it's
read,
not
write,
fair.
and understand English. That's not an issue
not-
here, sir.
It's not fair
Are
to
you
say-
self-represented? Absolutely. Does that?
As disgusting as it is for us to hear her so-called compliments of his abilities, she is putting on the record that he is not crazy, even though he's behaving like a pure peanut right now. There is no doubt. That is what that is, in my opinion.
That present difficulties and disadvantages? Absolutely. But that takes me back to when you waived your right to counsel. And you did so knowingly, freely, voluntarily, and with a full understanding of the disadvantages and advantages of doing so, meaning advantages of having an attorney, the disadvantages of doing it on your own, and you made a deliberate decision to
Your Honor, that's
represent
not fair.
yourself, and that comes at a risk to you of, yes, at times not fully understanding the law, the rules of evidence, the rules of procedure, but you
That's
do
not
so
fair.
at your peril.
That's not fair to state, Your Honor, because
So I'm going to do the
correct-
following, since I'm not really
Okay.
getting anywhere. I'm going to mute you for the moment. I'm not getting anywhere with him. I would like him to be brought over, and he has a choice to make. He can come back over, or he doesn't. Either way, he's going to be asked to call a witness in front of the jury. I will ask him 3 times if he fails to give me a direct answer, and after the 3rd time, I will make the appropriate finding, but I will do that outside the presence of the jury. But we are going to continue. So we'll go off the record, and he will come back over here. Thank you. We are in recess until that happens.
I mean, just to say something and then get kicked out. Man, I don't know what to tell her then.
This is a total meltdown. This is the meltdown.
No. Because I'm going to end up having to come back over here. Don't y'all get tired of hauling all this stuff over here,
Nope.
over there, over
Nope.
there, over there?
Nope, they're not tired of it. It's the final meltdown. It's the final meltdown. Not the final one, but the one of them. It's the final meltdown.
The record stands.
That was probably subject matter jurisdiction.
So
I'm
is
not
that
back
a tacit
with it.
agreement?
Oh my
You don't have to
god.
answer that question, Your Honor.
I make no such agreements with you, sir.
Thank you.
So that means you can answer a question then. Will we be addressing subject matter jurisdiction
It was
on the record, and will it be verified and proven?
verified and proven.
Non-responsive answer is a tacit agreement, Your Honor.
Jury's coming out. Thank you, everyone. Please be seated. The defense may call its next witness.
Who's here?
Bertram, Hayes, Aldrich, and Lescano are present and ready, Your Honor.
Thank you.
What was the last two?
Aldrich and Lescano.
Let's go with Deanna Aldridge.
Deanna Aldridge? All right, very well.
Put it back! Put it back! Put it back! Rolling his eyes.
I'm sorry, Your Honor. I think she was in the other building, so.
That's all right. Thank you for letting us know. Good afternoon, Miss Aldrich. If you would please make your way to the witness stand. It is up by me. It's up a riser. When you get all the way to the witness stand, please remain standing, raise your right hand, and my clerk, Teresa, who's on my left and will be across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Come up and have a seat. The first thing I will ask you to do is to state your first and last names for the record and then spell each.
Okay. Deanna Aldrich, D-E-A-N-N-A. Last name is A-L-D-R-I-C-H.
Thank you. Go ahead, sir, your witness.
Good afternoon, Miss Aldrich. Direct your attention. Well, first of all, let me back up a little bit. What do you currently do for a living?
I'm retired.
That's always pretty good. Direct your attention to the evening of November 21 of 2021. Do you recall that evening pretty good?
Yes.
Where were you staying at the time?
I live on Maple Avenue.
And during that evening, did you hear anything unusual?
I did.
And do you recall what that was?
I heard a large thumping noise in my neighbor's yard, and when I came out to my porch, I saw a red SUV.
Back up a little bit to the thumping noise. Can you describe that thumping noise? Would it just be a thumping? Did it sound like a crash or anything of that nature?
You are leading.
I believe it was like the engine dropping kind of noise.
Okay. And you stated you looked out your patio and saw a red SUV?
I did.
Do you recall how that SUV looked at that time?
It was smashed to smithereens.
Do you recall if the red SUV was still running at the time that you observed it?
Yes.
And at some point, did it cut off?
Yes.
And what did you see from that point?
Before I seen it shut off, I seen it go forward in the driveway and then back up like 3 feet. And then someone got out of the car and ran around the bushes to the front of my building.
And who's the someone that you are referring to?
At that time, I didn't have my glasses on, so I could not see clearly.
What do you recall?
As far as
description-wise, yeah.
Dark hair, possibly white or purple or whatever color shirt, and dark pants.
Do you recall a height?
A pigeon like mine.
I think he was probably anywhere between 5'6" and 6 foot. I really couldn't tell because of the angle.
So I'm assuming then your patio is kind of on a upward base type of angle that you would have kind of been looking
I was
sort of
looking
down?
yes.
Okay.
She still described you, Daryl.
And the individual you stated ran in what direction at the time that you were observing?
My porch is here, and he ran from the driveway here around to the front of my building.
Did you see where the individual went from that point, or could you not see because of where you were positioned on the patio?
He stopped to, if you were looking at the building, he stopped to the right of the building front.
And the building front, is that a street?
Yes. Not all the way to the street, though. He was in the front
Are
yard.
you trying to
of the
prove
house.
the prosecution's case? Because so far,
Did you at any time observe this individual jump over the hood?
I was running in and out of my house, so I did not see because I was trying to find my glasses as I was running in and out.
So is it fair to say you were trying to locate your glasses so you can get a better look at what you were observing?
Yes.
Do you recall if the SUV had any tinted windows?
I do not recall.
Do you recall what time of the evening you heard the loud thumping and then observed the SUV?
I do not recall.
And before that evening, had you ever noticed that SUV before that evening?
No.
Did you speak with any of your neighbors to inquire who the SUV may have belonged to?
No, there was people coming outside from the building that the driveway was, and they were going to walk up to the vehicle, but they did not because I yelled to them and said, "Don't touch it."
So that kind of would be fair to say that kind of startled them and stopped them in their tracks?
Yeah.
Do you recall how many people there were?
Maybe 10.
And at some point, did law enforcement come to your home and interview you about what you observed that evening?
Yes.
And do you know if they? Well, I'm assuming they took a report. Would that be fair to say?
They came up to my apartment and asked me some questions.
Do you recall if they were writing it down or recording it?
Writing it down.
she's uncomfortable. She's stressed. Look at her. Oh, poor lady.
If you recall, did you ever learn what the loud noises were that you heard before seeing the SUV?
No.
How does somebody feel if they're called as a defense witness for this monster?
And the street that you observed the individual running toward, do you recall what street that would have been based on the direction?
Arlington Avenue would be right directly in front of that building.
You didn't see the individual run towards Maple Street?
He ran towards Maple Street and came around the bushes directly to the right of my patio, being up high.
But that general direction would have been Which street did you say?
Arlington.
Arlington.
Moron.
I apologize.
Jazz.
Were you aware that there was a parade going on that evening?
Yes.
Did you attend?
No.
After you spoke with the law enforcement officers that evening, did any more law enforcement officers come back and interview you at any time after that evening?
They did not interview me that evening. They came early the next day on the 22nd.
Oh, I'm sorry. After the 22nd, did any other law enforcement come back out to interview?
No.
Do you recall the name of the officer that interviewed you?
No.
That's a probative question.
No further questions
Thank
at this time.
goodness.
Thank you. Any cross?
No.
No cross, Your Honor. Thank you. You are-
Oh my god! He is totally clueless. That was such a waste. Oh my goodness. If you made it this far, thank you very much. Like, comment, and subscribe. Or I just like everybody joining. I see everybody subscribing, and I know I've been gone for a while. But there you go. I'm going to upload this one right away. What a total turd. I wish I could call this one the final meltdown. Oh my god. Okay, bye-bye.